Hi, I'm Miles Johnson, and today we're going to talk about what's involved in a trial or hearing. A trial is a finding of the truth. That's the court's job. Find out what is truthful and what is not so they can make a determination on the issues in front of them. How we do that is by both sides presenting their case in chief. A case in chief is similar to a play. It's very scripted, very well thought out, and what's going to be presented should be pretty tight. What I mean by that is there shouldn't be a lot of surprises. This isn't like the movies where there's a smoking gun at trial and that just blows things out of the water. That happens few and far between, especially when everyone's doing their job. Okay, so this is how a trial works. You go into court. The petitioner, that's the person that filed the initial document, whether it be a divorce or an APR, they get to go first. They get to call their witnesses, and the respondent gets to cross-examine those witnesses. The petitioner gets to redirect those witnesses. Then the petitioner sits down. They rest their case. Then the same thing goes for the respondent and their case in chief. They get to present their case through witnesses, exhibits, other evidence, and then the petitioner gets to cross-examine those witnesses and evidence, and eventually the respondent gets to redirect their own witnesses. Then they sit down. And then petitioner actually gets a chance to call what's a rebuttal case. That's to rebut some of the things that respondent brought to the attention to the court. So if you think about that, the petitioner or the moving party, they get kind of two bites at the apple. One at the beginning presenting their case in chief, and then one at the end having a rebuttal. From there, there's often closing arguments. These are the attorney's chance to get up and talk about all the evidence that was presented. Your Honor, you heard from mother that she has not provided any sort of information to father about any medical issues that this child's been going through, and yada, yada, yada. Right? They really bring in all the evidence that was presented to the court and ask the court for some sort of remedy, hopefully in a persuasive manner. After that, the court will do one of two things. They'll issue an order right there. I've heard the testimony in front of me today, and I've decided that parenting time should be as followed for these reasons. Or, which is happening quite often with the amount of cases that we have in the Denver metro area, the court will take the matter under advisement. What that means is the court needs some time to think about it. We've heard all this evidence today, and now I need some time to think about it. I will issue a written order basically when I get around to it. That can be a few days out, that can be a few weeks out. But often enough, courts are taking matters under advisement. So what that means for you is, although you've been working up and preparing for your day in court, don't bank on there having resolution that day. If you do, great. But be mentally prepared that the court's going to need some time to think about it, and you'll get your resolution as soon as the court provides it. That's how a trial works. There's a lot of preparation leading up until trial, but that is the general gist of what you should expect on your trial date.